Um, Good afternoon. My name is Dr. Xolisile Khanyile. I am from the University of Zululand. My title for my paper today is Guilty Until Proven Innocence, an examination of reverse honors in South Africa. Introduction. Reverse honors clauses appear in statutes covering drug offenses, domestic violence, corporate crimes, fraud, and game trading related offenses. These provisions require that the accused to prove innocence or raise a valid defense or a reason, and which is typically contrary to the usual presumption of innocence. Courts have consistently, more specifically the Constitutional Court, struck down the reverse honors clauses because it violates the right to a fair trial, right to remain silent, and these can be noted in case law, State versus Miller, and State versus Sophia. Although Section 36 allows for the limitation of rights, reverse honors clauses rarely meet the criteria for justification. The legal challenge lies in enhancing crime control without undermining social rights and the foundational of freedom of speech. Furthermore, despite the constitutional guarantees of presumption of innocence as entrenched in Section 35, South African law still contains reverse honors provisions in serious criminal offenses. These provisions appear in legislation dealing with drugs and trafficking, crimes, firearm possession, fraud, corporate liability, and terrorism-related activities. The state often justifies reverse honors clauses on grounds of the prosecutorial efficiency, particularly when the accused alone holds typical evidential knowledge. However, the Constitutional Court has consistently invalidated reverse honors provisions that it places an unjustified limitation on the right to a fair trial. Some reverse honors clauses remain entrenched in our legislation, creating uncertainty about their constitutional validity and practical enforceability. This is an ongoing tension between effective law enforcement and constitutional rights, and it calls for a critical evaluation of the legal and procedural legitimacy of the reverse honors provision. What are my research questions? Number one, to what extent do reverse honors provision in South African criminal law infringe upon the constitutional right to be presumed innocent as entrenched under Section 35 of the Constitution? And secondly, how have South African courts, particularly the Constitutional Court, interpreted the rule on the constitutionality of the reverse honors clause in statutes such as the Criminal Procedure Act and the Drugs and Trafficking Act and other relevant legislation? Thirdly, what are the legal reforms or judicial safeguards that are necessary to ensure that the reverse honors provisions remain effective and have a procedural purpose while complying with the constitutional standards of a fair trial and due process? Now we're going to define what is a reverse honors, particularly dealing with the legal framework that define what is a reverse honors. In South African criminal law, reverse honors provisions are commonly applied as submitted previously in first offenses, and where proven intent or knowledge causes a challenge for the prosecution. Statutes such as Drugs and Trafficking Act, firearms control, impose a presumption that shifts the burden to the accused to prove that they were not dealing with drugs, neither the firearm that they had in their possession was actually in their lawful possession. Furthermore, corporate criminal liability laws, particularly Section 332 of the Criminal Procedure Act, holds directors accountable that they need to show that they make the knowledge of the criminal activity, and that they had no knowledge of actually preventing such criminal activities. Furthermore, there's environmental, customs, financial, and competition legislation, which also includes reverse honors clauses, requiring the accused to justify actions or to prove his innocence under specific presumption. In bail proceedings, and anti-terrorism law, the burden similarly shifts to the accused to demonstrate exceptional circumstances or to also prove the lawful possession of a prohibited material. Although designed to support law enforcement in combating organized and short crime, these provisions must meet the constitutional test and justifiability under Section 36, which is the limitation clause, and the court often strikes down those that impose disproportionate burdens on the accused. So what are the judicial interpretation and constitutional court jurisprudence in this regard? Number one, the Constitutional Court has developed a clear framework for assessing reverse honors provisions. Through landmark cases such as State v. Sophia, State v. Bulana, and State v. Melo, and State v. Khanyile. The presumption of innocence now enshrined in Section 35, Section 3 of the Final Constitution of Southern Africa is a fundamental element of a right to a fair trial, and it prohibits the shifting of the burden to the accused person. In State v. Sophia, the court ruled that requiring the accused to disprove the knowledge of fraud-related offences violates the presumption of innocence and constitutes an unfair legal burden. In State v. Bulana, the court found that the presumption of drug dealing based on a possession or threshold of quantity imposing a disproportionate speculation on the burden, rendering the provisions unconstitutional. In State v. Melo, reaffirmed that the state's difficulty in proving the knowledge does not justify imposing a legal duty on the accused to prove their innocence in such serious offences. In State v. Khanyile, the court found that even for less serious offences like trespassing, placing a legal burden on the accused to prove their lawful presence does violate the Section 35, Section 3, H of the Constitution. And then 7, collectively, these cases do establish reverse honors provisions and their unconstitutionality when they relate to essential elements of the offense, and are rarely justified under Section 36, which is, of course, the limitation clause. Unless the state can prove its necessity, proportionality, fairness in a democratic society. What are the applications of Section 36, which is obviously a section based on our Constitution called the limitation clause? It states that yes, there are rights as entrenched in the Bill of Rights. However, all the rights have their limitations. With that being said, not all reverse provisions are automatically unconstitutional. Some remain valid if they pass the limitation test under Section 36. Section 36 allows rights, including the right to a fair trial, under Section 35 to be limited in reasonable and justifiable in an open democratic society. Courts apply proportionality tests to assess whether the reverse honors provision serves as a legitimate purpose or whether restrictive measures could achieve the same goal. The state may justify certain reverse honors clauses by citing urgent objectives like fighting organized crime, drug trafficking, and crimes, or economic fraud. Courts may tolerate limited evidentiary burden on the accused, especially when they hold expressive knowledge of the key facts that are difficult for the prosecution to prove. With that being said, yes, all the rights can be limited, but reverse honors does not. I think it's for the benefit of the state, especially in these cases where maybe they need to validate or even investigate cases entirely. So they rely on the accused to come and explain, then they penalize for that. Ultimately, reverse honors provisions must be narrowly tailored and repeatedly be justified to avoid undermining the presumption of innocence and a fair trial. Law enforcement efficiency and personal rights. The lack of competent resources, specialized investigative units in South African police service significantly increased reliance on reverse honors provisions and a prosecutor shortcuts and in complex organized crime cases due to chronic under-resourcing, inadequate training of the SAPS, often fail to gather enough evidence to meet the constitutional standard of a state is supposed to prove a criminal case beyond a reasonable doubt. Consequently, reverse honors causes shift the investigative burden to the accused, requiring them to provide an explanation to rebut the presumption, which undermines the presumption of innocence. This right highlights the need for institutional reform to strengthen the law enforcement capabilities rather than compromising fair trial rights by relying on burden shift mechanisms. The danger of undermining the core constitutional values. The use of reverse honors provision poses a high risk, or rather a serious risk of justice, of a risk of miscarriage of justice, precisely because it undermines the core constitutional values such as presumption of innocence, the right to remain silent, and the right to remain to a fair trial. By shifting the burden of proof to the accused, often it disproves the intent, knowledge, or the participation of the provision and increase the likelihood of conviction and conviction of individuals who may be factually innocent but are unable to discharge the evidentiary burden due to the lack of legal knowledge, resources, and access to necessary evidence. This means that, then the third thing said, the danger is particularly acute in society like South Africa, where socio-economic disparities and limited access to legal representation can leave the accused in such a vulnerable state. In conclusion, in summary, this article has demonstrated reverse honors in South African criminal law significantly they infringe upon the constitutional rights to be presumed innocent, particularly where the shift of legal burden of proof into the accused in relation to essential elements such as intent, knowledge, and participation. It must be noted that the state's burden is to prove the case beyond a reasonable doubt, whereas the burden of proof which the accused having to explain is on the balance of probability. As the analysis of the three constitutional judgments, such as Ace versus Castillo, State versus Zululand, State versus Melo, State versus Leo, has shown that judicial has consistently held such provisions as presumptively unconstitutional unless the past scrutiny test of justification under Section 36. But the case is still stands. Yes, it's there, but is it still applicable? Today in court, practically, an accused failed to discharge the honors and the fairness of the by explaining to the court that the items that were found in the possession are not stolen, or the amount of drugs that are in my possession, it does not mean that I'm a drug dealer. All right, just to proceed on that. All courts have acknowledged that the state may invoke reverse honors in pursuit of legitimate objections, such as committing organized crimes or committing misconduct. The burden of proof must not be compromised by prosecutorial inconvenience or institutional challenge. Accordingly, some reverse honors clauses remain embedded in our statutory framework. Their constitutional compliance is increasingly uncertain, thereby generating an ambiguity and undermining legal clarity. In the light of this finding, it is imperative to reaffirm that constitutional demands not just only justice in the outcome, but justice in the process. Therefore, there is an urgent need for a principal legislative reform that carefully limits the scope and the application of reverse honors provision, aligning them with the constitutional norms contained provision of South African Bill of Rights. Simultaneously, an ongoing judicial vigilance is essential to ensure that any limitation of the third trial is proportionate and necessary, and at least restrictive means are available. Only through this broad process, a clear legislative boundary and a robust constitutional education, adjudication can the criminal justice system safeguard individual rights while remaining effective, credible, in addressing serious